So another rule governing consideration is the Pinnell's rule, and this is in case of part payment of debts. So Pinnell's rule is a legal principle from the Pinnell's case, which states that part payment of a lesser amount of money than the full debt, even if it is made on the due date, cannot legally satisfy the entire debt. So this rule implies that a debtor must pay the full amount owed, and a creditor is not bound by a promise to accept a lesser amount unless there is something additional or different offered in return. In this case, if a debtor offers to pay part of the debt and the creditor agrees, then the creditor can still sue for the remaining balance. That is the Pinnell's rule. So, for example, where the debtor offers to pay £75 instead of £100, and the creditor agrees to accept the lesser sum as full settlement. So the creditor is not legally bound to forget the remaining £25 unless there is something extra involved. So according to the rule in Pinnell's case, payment of a lesser amount on the day in satisfaction of a greater is not considered valid consideration for the full debt. So this means that the creditor can still sue for the remaining £25 even though they agreed to the lesser amount of £75. However, there are exceptions where the debtor may be able to settle the debt with a lesser amount. Let's look at the exceptions to Pinnell's rule. So the general rule from Pinnell's case and for Wax versus Beer is that if a debtor pays only part of the debt, even if it is on the due date, and the creditor promises to forgive the remaining balance, the creditor is not legally bound by the promise because part payment is not considered sufficient consideration to fulfill the entire debt. However, there are exceptions to this rule that we are going to be looking at, the common law exceptions. And the first one is part payment by the debtor on an earlier date of the debtor's request. So, if the debtor pays part of the debt before the due date, then the creditor may be bound by their promise to accept it as full settlement. So early payment can be considered sufficient consideration in some circumstances. If the creditor tells the debtor that if you pay my money before the 20th of February 2025, I can accept £75 instead of £100, and then the debtor goes ahead to pay the £75 before the 20th of February. So it means that the creditor cannot later on come and claim for the remaining £25. So part payment by the debtor on an earlier date at the debtor's request can count as sufficient consideration. Then we have part payment by the debtor at a different place at the creditor's request. Another exception we have is part payment by the debtor at a different place at the creditor's request. Let's assume I owed you £100 to be repaid in London today, but this morning you ring me up and say that you will be in Brighton today, and it is more convenient for you to be paid in Brighton. So I say to you that I'll have to spend time and money traveling to Brighton, so I'll only be able to pay £80 if you want the money to be repaid in Brighton. So you say to me that you will accept the £80 in full satisfaction of the debt. So in accordance with this agreement, I pay you the £80 in Brighton. So if then you decide to sue me for the balance of £20, you will not succeed because I have conferred a benefit on you by paying you in Brighton where it was convenient for you. So if there is part payment by the debtor at a different place at the creditor's request, then that can be considered as sufficient consideration. Another exception we have is when the debtor offers something other than money as payment and the creditor accepts this in full satisfaction of the debt. So if the debtor offers something other than money, it can be goods, services, and then the creditor accepts it in full satisfaction of the debt, then it's considered sufficient consideration. Now let's assume that I owe you £100 and today is the date of repayment. So when I meet you today, I inform you that I have no money, but I can offer you a copy of the entire set of my lecture notes. So if you're willing to forget about the debt, so you have missed many of the lectures and you see that this is an excellent opportunity for you to catch up. So you accept my offer of the lecture notes and promise to forget about the debt. Unfortunately for you, you will not be able to sue me for the debt as I conferred a benefit on you by giving you my lecture notes in compensation for the debt. So if the debtor offers something other than money as payment and the creditor accepts it in full satisfaction of the debt, then it is considered sufficient consideration. Then we have another case where a third party makes a part payment to the creditor. So if your father or mother or partner makes a part payment for your debt to your creditor and your creditor accepts the part payment in full satisfaction of the entire debt, but then decides to sue you later for the balance, you have a good defense because that part payment by a third party and it was accepted by the creditor, it counts as sufficient consideration. So those are the exceptions to the Pinnell's rule.